This is LLA 101, an introduction to legal skills, or otherwise known as how to think like a lawyer. We're dealing now with Module 3, the issue in dispute. Okay, so let's just step back. Okay, we're dealing with FELAC. We've done the facts. We're now doing the I, the issue in dispute. That's the kind of second aspect of this. Now, in order to understand this question of issue in dispute, what I need you to understand is that this is the legal question that is posed. Okay, so another way to understand the issue in dispute is what's the problem, what's the argument about. But before I get there, I need to explain. Go back a little bit. Explain that academically, at least, the law in labor law is divided into individual labor law, and that's the law relating to the individual employee. Things like the conditions of employment, dismissals, duties of employees, and of the obligations of the employer, and so on. That's all under, this is academically speaking, okay? Divide labor law into individual and then collective. The collective then is, we're dealing with things like unions, strikes, collective agreements. Okay, what's a collective agreement? It's a contract that is entered into between unions and employers. So not between, a contract of employment is between an individual employee and an individual and a company. Okay, but so a collective agreement is one where it's also an agreement, a contract. And the Labour Relations Act has special, because it's a special type of agreement, there's a whole lot of provisions in the Labour Relations Act around that. Collective bargaining, that is where unions would bargain, negotiate with companies for wages and terms and other terms and conditions of employment. Bargaining councils, you have the CCMA, you have bargaining councils for particular sectors, where they then will set wages and deal with disputes in that sector. Okay, so that's all collective labor law. Right, now when it comes to the practice or the application of understanding the issue and dispute, the first thing I want you to understand is that you frame it, and this is best practice, okay? You frame the issue and dispute as a question. You always do that. I'll tell you why. And this is just my way of doing it, okay? Is that when you frame a question, you then answer the question. The problem is, of course, that if you frame the question incorrectly, you'll ask the wrong question and you'll therefore answer the question wrong. So in the exercise that I gave you with Mr. Dudu and so on, if you frame the issue and dispute as something like, does Mr. McKenna, that's the supervisor if you remember, want to dismiss Mr. Dudu, then you're going to go down a whole track of looking at evidence or facts around that, when in fact the issue and dispute was, did Mr. Dudu assault the other employee? If you do that, you'll follow the correct track, if you like. So you need to understand, there is a fair amount to understand about this, in the sense that the issue in dispute is related to the allegation, the charge that the employee is facing. So if the charge is insubordination, that's the title or the type of misconduct, then you would expect an issue in dispute to be framed something like, was Mr. Smith insubordinate to the Mr. Jones, the manager, on this date at this time? Okay, something like that. Question mark. Then you seek answering it. So it's got to do with the allegation, it's got to do with the reason for the hearing or the arbitration later, the reason why there's a dispute. Without that, basically nothing else follows. So that's why this is so important to get right and to understand what we're doing here. The question is also, just to make it plain, there's no need to answer the question at this stage. Remember, we're going through a process. We're going through a thinking process. We're saying, what are the facts? What is the issue? And so you don't necessarily now have to answer it. Think, oh, what is the answer? What you're doing is you're framing the question. And then what do? You look at the law because it's FELAC. But remember, you're going to look at the law incorrectly if you framed it as something else. So there is definitely something to learn here, because this is very important to understand. Just to, if you have been involved, maybe you're doing this course and you do have some experience with arbitrations and that kind of thing. What I find is that certainly the arbitration awards that I read, which is obviously just a small number of them, but most arbitrators will frame the question around the general idea. Was Mr. Jones's dismissal unfair? When in fact, if you read it, you'll see that the actual dispute is, for example, whether he was insubordinate or not. So what I'm trying to say to you is that what I'm trying to teach you actually applies right through when you're chairing a hearing, or when you're investigating, number one, when you're chairing a hearing, when you're arbitrating. And you'll find that many people don't actually frame the issue in dispute, number one, or if they do it incorrectly, or as I've said, they frame it as like this broad dispute, when in fact it's a minor dispute. And that's the point that I'm trying to get to, is that amongst, when we'll go through the elements later, you will see that that it's all very well to understand the broad dispute, like dismissal, but actually there are different types of dismissal. So which form of dismissal? Now I'm jumping a little bit to what we'll cover later, but you need to understand that this is a very important principle, very important skill to understand. Okay, so I have an exercise for you, and it's very similar, but we're trying to learn how to apply FELAC to understand the issue and dispute, and now we're going to test you to see if you can frame the issue in dispute correctly. Now, question 1. Your union is of the opinion that it has a majority membership at Widgets Pty Limited. Management insists that it does not. Just to explain a little bit, in case you haven't done this before. So it's a union, all right, not an individual. I think most of us understand what a union is. It says majority membership. Majority members means 50% plus one of the workers. And I've called the company Widgets Pty Limited. The fact is Pty Limited means it's a company, okay? It's a play company. I use that name for you, so just get used to that. Okay, so that is the first thing to go through. Just make sure you understand that. Second, your union enters into a collective agreement. I've explained what a collective agreement is. But the union and management subsequently differ over what clause 4. So clause 5.4 would be one clause in that agreement. The third one is a member of a union tells that she worked for Widgets Pty Limited, was retrenched. She was never told why she was retrenched. 4, you're told by a member of your union she was retrenched after working for 7 years. She was not paid any severance pay. She wants to be paid severance pay. Sam Smith, number 5, dismissed, tells you the reason was dismissed. The company said he came to work drunk. He says he was not drunk and wants his job back. 6, you're a chair of a hearing in the company. Allegation, the employee Johnny Geldenates, who's subject to hearing, is listed notice to tender as absent from work. I'm just going through these because if there's anything in there that you may be not sure about, especially if you're doing this like for the first time. You're the HR manager at Widgets, an incident of sexual harassment. I think you know what sexual harassment is about. Okay, and then that one. Number 8, you're a chair of a hearing, told by an employee subject that he was not informed of the allegations. Okay, all right. So this is again I'm going to ask you to pause the video and to see if you can get. Now, you may find this difficult, so if you get it wrong, don't worry, because as I said, with all of these things, you'll start to understand more and more and more, certainly as you go through the process of this course. So, what's the issue and dispute? Number one, well, the issue of dispute, does your union, see the question, does the union have a majority membership at Widgets? Now, why do I say that? Why do I say that's the issue in dispute? Well, first of all, that's the core of the argument. Management says they don't. Widgets, the union says they do. What's the argument? Or what's the question? Does the union have a majority membership? What I'm trying to also make you understand is that it's not that you're taking sides at this stage. You are trying to ensure that you get to the nub of the real reason for why is there this dispute. You could get it wrong, for example, and say, well, the question is, does the union have a majority membership? And that would be the key of the argument between management and union. Right. Number two, the collective agreement. What's the issue and dispute? What does clause 4.5 of the collective agreement mean? Okay, that would be how you would frame that. Now, just to move it on so that you understand, this is not just in in a play. This is the type of dispute that actually the CCMA deal with. There's sections in the CCMA, in the Labour Relations Act about collective agreements and about disputes, and it's an example of a real type of dispute because there's argument about what that particular clause in the collective agreement actually means. How do you interpret it? Member of the union, all right, that's the third one. Tells you that she worked for Widgets and there was retrenched. She was never told why she was retrenched. And the question would be, was the employee's retrenchment fair? Okay. Question mark. Now you'd investigate that. Now you would, if you framed it correctly, once the person tells you that, then you're now going to investigate correctly. You're going to find out the facts. You're going to look for evidence, etc., around this question of was she retrenched? What happened in the process of retrenchment, etc. And because she says she was never told why she was retrenched, so the question is, was it a fair retrenchment if she wasn't told? I hope you're getting a sense of what these things are about. Okay, told by a member number 4, retrenched after working for the company 7 years, not paid any severance pay. She wants to be paid severance pay. Is the employee entitled to severance pay? Always framed as a question. Now, you can get that kind of thing wrong because you start now checking, like, was the retrenchment fair? That's not the issue. She's not coming to you saying, no, the retrenchment was unfair. She's saying, I was retrenched, but I wasn't paid severance pay. I want to be paid severance pay. What's the issue? So you focus on that, not on the whole question of the retrenchment, etc., because that's not the issue in dispute. Sam Smith, number 5. Right. There's a classic 80%, whatever it is, of disputes at the CCMA is around dismissal and the fairness of a dismissal. So that is the core of the kind of disputes that one will deal with. So the broad question is the dismissal of Sam Smith fair? Second issue in dispute, was he drunk at work? Okay, if he was drunk at work, the dismissal may well be fair. If he wasn't drunk at work, then the dismissal may be unfair. Okay, so you go nailing exactly what the dispute is about. And my little explanation just now about what happens with CCMA is pertinent there. Number 6, you're chair of the hearing. The allegation against employee Johnny Geldenhuys, who's the subject of the hearing, is listed in notice to attend as absent from work. Okay, so you're moving now into the status, you're chairing a hearing. You're told what the allegation against this employee is, that he was charged with being absent from work on the 25th of May 2000 and whatever. What's the issue in dispute? If you now frame this incorrectly as chair, you're going to go down the wrong road. Was Mr. Geldenhuys absent from work on the 25th of May 2000 and whatever? Frame it correctly. You're the HR manager, Widgets, an incident of sexual harassment was reported, told by the CEO to investigate. You're told that Michael Reddy touched the breasts of Sally Andrew while they were at a conference in the Magaliesburg. What's the issue in dispute? Did Michael Reddy sexually harass Sally Andrew while at a conference in the Magaliesburg? Okay, I hope you're getting the idea. I see in my slide I haven't put it as a question mark. Whoopsie, I should get into trouble there. Number 8, you're chair of a hearing. The commence of the hearing, you're told by Luzanne Pretorius, the employee who's the subject of the hearing, that she was not informed of the allegations against her. The company representative disputes this, says the employee was informed by SMS sent to her cell phone. What's the issue? Was the employee informed? You've got two versions of this. Company says they sent an SMS. She says she was never informed. Okay, so you're going to now investigate, and that's a typical kind of thing that happens in a disciplinary hearing, and you need to frame that correctly. In other words, and proceed on that basis. Okay. So, what are the key learnings in terms of this issue in dispute? In order to correctly state the issue, you must phrase the issue as a question. Ask the wrong question, you'll get the wrong answer. The dispute is a statement of what the disagreement is about. You state the issue and only later do you answer your own question. The skill of stating the issue in dispute arises in all sorts of contexts. That's what I've tried to explain or illustrate in this.